do a sound check. Can you just give me a thumbs up? Give me a thumbs up if you can hear me. Okay. I have shared your first assignment with you. It's fairly straightforward. There's nothing particularly complicated about it. Please read the instructions very carefully. And specifically, the instruction that you should only use the notes, the prescribed study material to answer the assignments. Do not Google, do not AI, do not ChatGPT, because you will get 0. I compiled the study notes. I know what is in there. So the moment you start referring to concepts that go beyond the study guide, I will know that you did not. The idea is not for you to quickly Google something and copy and paste. The idea is to work through the notes and try to answer the questions in the assignment. They are not overly complex. They are not overly complicated. You should all be able to do everything there. I have a tendency to repeat the questions that I have in the assignment in the tests and exams. If you have actually answered the questions yourself in your assignment and you get the same question in the test or in the exam, you will be able to answer it in the test or in the exam. If, however, ChatGPT answered it for you, in the exam, there is no ChatGPT. You have to write the answer with a pen on a piece of paper. No ChatGPT that can help you. And then suddenly you haven't. Whereas if you did it yourself the first time around, you will remember what you did, how you figured it out. If you copied and pasted from somewhere else, you get to the exam and it's the first time you've seen it. Please, people, take me seriously. Let me share my screen. Okay, just a thumbs up quickly if you could see the screen. Thank you, Mr. Mackay. Okay, it's the same page that I used last week that I just continue with. Every time after we've finished a particular piece of the work, I will just tidy up, clean up my class notes, and then I will share them with you as well. Now, what I did today for today's class, in order to speed things up a little bit so that I don't spend so much time typing, I've actually copied some notes that I made when I was teaching my accounting students. I also teach a course called Introduction to Law for Accountants. I haven't uploaded any of their class recordings yet. I will hopefully do so this afternoon still. Also on my YouTube channel. At the moment, just for now, in a week or so, the courses, they do different things that you don't do and you do things that they don't do. But at the moment, the introduction to the general law of contract, I'm doing with my sports law students as well as my introduction to law for accountant students. ITL is level 5, sports law is level 6. So the assessment will vary, but obviously the course content is the same. With them, I go a little bit slower because it's level 5, but slower than I do with you. Feel free to also listen to those recordings. Covers the same work if you might find it useful. So we're looking at the 5 requirements for a valid contract. We saw that a contract is an agreement with a serious intention of bringing about obligations. In order for these obligations to arise, in order for them to be rights and duties, the contract must be valid. And there are 5 requirements for a valid contract, namely consensus, contractual capacity, performance must be possible, performance must be legal, and then if there are any required formalities, these must be followed. So looking then today at the concept of consensus. To be a valid contract, there must be consensus. What is consensus? Consensus is an agreement between the parties to the contract, a complete agreement about the same thing, the same understanding about the subject matter and the obligations that are to flow from this contract. You should start seeing the patterns here. What is a contract? An agreement between 2 or more parties. What is consensus? An agreement. It's not a different thing. It's the same thing. So there must be consensus. There must be an agreement. How do we achieve consensus? Elements of consensus are offer and acceptance. So one party makes an offer and the other party will accepts this offer. There must be a valid offer plus a valid acceptance. Now, you've surely noticed by now that law is full of requirements. There are requirements for a valid contract. One of those is consensus. Then we get requirements for consensus. What are the requirements for a consensus to exist? Firstly, the serious intention to create legal obligations. We've got a repetition again here. Agreement between the parties with a serious intention of bringing about obligations. So consensus is, in fact, the requirements for consensus are contained in the working definition of a contract. There must be a serious intention to create legal obligations. The content of these obligations must be in common. Everybody must think the same. It must be, there must also be a complete agreement about the parties that are going to make that to the contract. This is equally important in all contracts. If you're buying a loaf of bread, it doesn't really matter who you're buying it from. Shopkeeper doesn't particularly care who's selling it. But you can think, on the other hand, as students of sports management, that when it comes to contracts within the realm of sport, if a club is appointing a specific or giving a contract to a specific player, there must be a complete agreement about the parties that are part of this contract. Um, if whatever NAS soccer club wishes to give a contract to Mr. Lynx, they don't want to give a contract to Mr. Mackay. So, complete agreement about the parties to the contract. And then, together with a serious intention to create these legal obligations, the parties must be aware of the obligations and aware of the consequences. They must know what they're getting themselves into. So we've seen that in order for us to reach consensus, there must be a valid offer coupled with valid acceptance. Now, when will an offer be valid? What are the requirements for an offer to be valid? Firstly, the offer must be complete and definite. It must contain all the necessary information, everything the parties need to know in order to fully understand and commit themselves. The party to whom the offer is made should be able to accept the offer merely by saying yes, merely by nodding their head, gesturing yes, thumbs up. The moment they have to start asking further questions, then it is not complete and definite. So if I'm offering my car to Fabiola, I say to her, Fabiola, will you buy my car? And that's all I say. That is not a valid offer. Why not? Because I didn't tell her what she must pay for the car. Fabiola, will you buy my car for $300,000? That is a valid offer. She can say yes, or if she doesn't want to accept the offer, she can say no. But the moment you have to ask more questions to clarify things, it is not a valid offer. Offer must be complete and definite. It must be made with a serious intention to be legally bound. I'm saying to her, Fabiola, will you buy my car for $5? I'm obviously not serious about this. It must be intended for the offeree, although the law does accept that offers can be made to the general public. And the offeree must be aware of the offer. You cannot accept something if you don't know that it exists. Just correcting the reference here. Have a look at paragraph 3.2. You can have a look at that yourself. It's just very brief. In terms of our law, an advertisement is not an offer, but it is merely an invitation to do business. So if a shop offers bread for $5 and subsequently refuses to sell it to you for that amount, you cannot take the shop to court. An advertisement is in fact construed not as a binding offer, but as an invitation to come and do business. Of course, what I'm saying now, what I'm talking about now, are the strict legal principles. But if a shop is regularly offering special offers and doesn't actually stick to that, it's going to be bad for business. Legally, they don't have to stick to it, but they will lose their customers very quickly. Now, obviously, moving on, offers do not last forever. If I make an offer of something now, I cannot be bound to that offer forever and ever and ever. So, how do offers come to an end? How do they fall away? Number of manners. Offers can fall away by way of revocation, withdrawal. Somebody has made an offer, they are free to withdraw that offer at any time until it has been accepted, prior to it being accepted. If it has been accepted, they can no longer withdraw it. You can also have offers for a fixed period of time. So I make an offer and I tell you, please respond before the end of the month. End of the month comes and you haven't accepted or rejected it, the offer will fall away. Effluxion, I hate the word effluxion. You can use expiry as well. There's no particular time period attached to the offer. Offers will fall away within a reasonable time. Reasonable, that is a word that lawyers love using if they don't have a specific answer to anything. When is a reasonable time? That will depend on the material circumstances. If I'm offering you my house for sale for $5 million, that a reasonable time for you to consider that will obviously be longer than if I'm offering you my cell phone at $500. Then an offer will also fall away if it has been rejected. The moment you say no, the offer falls away. If you make a counter offer, so I've offered my car for 500,000 and Fabiola says, I'll pay 300,000. She has in fact rejected my original offer. A counter offer is seen as a rejection of the original offer. And once she said, no, I'll pay 300,000, that is in fact a new offer that she has made, which I can then choose to accept or reject. And then legal death or legal incapacity. If I die or become legally incapacitated before the offer has been accepted, it will fall away. Now, with regard to the continued existence of an offer, there are two legal concepts that you must be aware of, namely an offer, an option, and a preferential right. Well, I'm going to talk about here. Take note of this. This is actually included in, I believe, question 1 of your assignment. What is an option? An option in law of contract does not have the same meaning as the common word option that we use in English. Sometimes you'll say, well, ask somebody something and they'll say, well, what are my options? What can I choose between? Option in this regard does not mean that. An option is, in fact, a separate contract to ensure the further existence of an offer. So I have offered Fabiola my car for 500,000. She wants to think about it. She doesn't want me to withdraw the offer. She wants to keep me bound to my offer. So she says to me, can you give me an option until the end of April? And I agree. I say, okay, you've got the option to buy my car until the end of April. So there's an offer, buy my car, and then there is an additional agreement that we will keep the main offer open for a specified period of time. During that time, I am bound to my offer. I cannot withdraw it. So if Mr. Mackay comes and says, I'll pay you 500,000 for your car, I cannot accept his new better offer because I am bound to my original offer that I made to Fabiola. Only if she has rejected it may I then change the offer or offer it to somebody else. A preferential right, on the other hand, is similar, well, not quite similar to an offer, but it also deals with offers. A preferential right is also known as a right of first refusal. In this particular instance, there is no offer yet. This is the instance where a sportswear sponsor, agrees with an athlete that if another potential sponsor contacts them, they should first be in touch with their original sponsor, who will then decide whether to meet this new offer, yes or no. That is a preferential right. That is, in fact, the answer to the first question, question 1.1, in your assignment. So I hope you were listening. The right of first approval. So there is no offer yet. There's just an agreement that should I make an offer, I will firstly make it to a specific person. Any questions so far? Yes, Mr. Martin.
Good afternoon, ma'am. I just wanted to confirm with you, are these the notes that we need to be using to for our test and for our assignment?
The notes that I'm making at the moment are just my lecture notes. They are. Sorry. Okay, could you just, yeah, if your mic is also on, then I get feedback. The notes that I'm making at the moment are just my lecture notes. They are not nearly sufficient to get you through the exam, or through your assignment or through your test. I'm also saying a lot of things that I'm not typing out. The notes that you have to use to actually study are on e-learning. Go and have a look on your e-learning platform. You will see that it's divided into separate sections. There will be a section called Law of Contracts. If you click on that, there's a folder that says study material or something like that. Click on that, all the different units are there. There are also folders with PowerPoint slides that I made in previous years, and even some that I've pre-recorded lectures. It's all there. It's on e-learning. The notes that I'm making now as I go along will definitely not help you. They will help you. They will help you. They offer like an outline, a skeleton. But just studying the notes that I'm typing while I teach is definitely not going to be enough. Any further questions? Okay, let's carry on. So we've done options and preferential rights. So an offer is consensus, the elements of consensus, a valid offer coupled with a valid acceptance gives us consensus. We've seen what the requirements are for a valid offer. What are the requirements for a valid acceptance? The acceptance, whereas the offer must be complete and definite so that it can be accepted merely by saying yes. The acceptance must be unconditional and unequivocal, clear, straight, simply yes. The moment you say yes, but, yes, I'll buy your car, but for a lesser price, it constitutes a counter offer, which is in fact a rejection of the offer. It must be in response to an offer. You cannot accept something if you can't accept an offer if it has never been made. Must be made by the person to whom the offer was made and communicated in the manner prescribed. So if I tell you, please confirm in writing, phoning me, making a phone call is not a valid acceptance. If there is no manner prescribed, the general principle is that acceptance can be made in the same manner or must be made in the same manner as the offer was. So if it is a verbal offer, acceptance can be made verbally. And then while the offer still exists. In response to an offer, while the offer exists, if the offer has been withdrawn or has fallen away, you can no longer accept it. Paragraph 5 is all about signatures. You can just look at that yourself. Paragraph 6, time and place. You can leave that bit out. I will not be assessing that. Don't actually know why I put that in your notes. So that is Unit 2. Moving on then to Unit 3, factors influencing consensus. When we started, we saw that a contract can be, in order to have obligations, the contract must be valid. If it is not valid, if one of the requirements is missing, it is void. It is a nothing. There are no rights and duties which flow from a void contract. But we also learned that sometimes a contract can be voidable. Now, voidable, oh, I have got it there. Voidable is not something in between valid and void. Voidable is a contract which is valid. So all 5 the requirements is there, but something is wrong with one of them, and accordingly it can be set aside. If it is not set aside, it remains valid. So there are certain factors that can influence the existence of consensus. The first one being mistake. Now, mistake literally means what it does in the English language. Mistake, in the terms of the law of contract, is a misunderstanding. A misunderstanding about the identity of the other party or the obligations which influences the decision to contract. So you think you are lending something, but actually the other party has offered that you can have it for hire. They want to be paid, but you think you're getting it for free. So you accept, but based on your mistake. Obviously, consensus is a complete agreement about everything. But if the one thinks white and the other one thinks black, the one thinks purchase and sale, the other one thinks lease agreement, there is no complete agreement that should make absolute sense to you. So obviously, if there is a mistake, there is no consensus. The contract is accordingly void. Not all mistakes that will void a contract. If Fabiola thinks my car is dark blue, but it's actually black, the contract will still be valid. If she thinks I'm giving her my car for free and I want her to pay for it, that mistake will mean the contract is void. When will mistake have the effect of rendering a contract void? It must be material, reasonable, and excusable. Material, it must go to the root of the contract. It must be reasonable, a mistake that anybody could have made under the circumstances, and excusable, so not based on negligence. Please read paragraph 2 there of unit 3. It gives you more information about mistakes being the requirements for a mistake being material, reasonable, and excusable. This is not applicable to you. Then misrepresentation. Misrepresentation can also have an effect on a contract, on consensus. What is misrepresentation? Misrepresentation, an unlawful, untrue statement made by one party to the other in order to induce them to enter into a contract. So this is where I am telling, yes, Mr. Martin, your hand is up. Mr. Martin, is that a legacy hand or is that a new question?
Yeah.
New question.
Sorry, ma'am. I just wanted to ask here, quickly touch on this issue of the mistake. And you gave an example of you saying your car is blue and then I think it's black. Would that not be worth canceling a contract? Because, for example, if I needed to buy it for a business and my business colors are black, yet I go buy a blue car, now I have to go and paint it black, just for it to go align with my other vehicle. Is that not even contract or grounds for it to be?
Mr. Martin, that is an absolutely excellent question. Thank you. I use the example, but in this particular case, it will depend on the circumstances. It will depend on whether you bought the car because you were specifically looking for a black car, because all the cars in your fleet are black, or you're running a funeral service and you want to use this car for a hearse. Then in that case, where a blue car will not be suitable, that will be a material mistake, and yes, the contract will be void. But on the other hand, for myself, whether If I looked at the car at a distance, because I'm guessing you don't buy a car without looking. So I looked at it, but the light was a bit bad. And I thought it was dark blue. And then when the light, and I buy it, and tomorrow when the sun is shining, I realize it's black. But it's just a personal car. It's not really such a big issue. It will not be material. So my particular example that I used will depend on circumstances. As you said, if you specifically bought it because it has to be black, then the color is material and the contract will be void. Thank you. Are you with me? People, please do interrupt me. Do what Mr. Martin did now. Just remember, I'm not when I'm teaching, I'm looking at my screen that has my notes on it. So you might raise your hand, and I'm not going to see you immediately. Feel free to put your mic on and just attract my attention. But do clarify. Um, okay, carry on. Um, okay, so we're talking about misrepresentation. This is where I've offered my car to Mr. Martin for 300,000. And I'm telling him the car is in a perfect working condition. Whereas I know that the CV joints need replacing. But I tell him the car is perfect in order to persuade him to buy this car. That is what misrepresentation is in legal terms: an unlawful, untrue statement made by one party to the other in order to induce them to enter into a contract. So what is the effect of misrepresentation on this contract? Mr. Martin has agreed to buy my car for $300,000. So there is consensus. He has agreed. The contract is valid. And please, people, when you study law, think with your heads. Don't think with your hearts. A lot of people will think, oh, but she lied to me, so how can it be valid? I don't understand it. It is valid. He has agreed, as simple as that. He is bound. He must pay me 300,000 in terms of our consensus. But because the contract was based on, because I misrepresented, because I persuaded him to enter into this contract by telling him a lie, there is something wrong with the consensus. There is consensus, but we achieved it in the wrong manner, which makes the contract voidable. So the contract is void, it is valid. All 5 requirements are there, but something is wrong with one of them, which makes it voidable, and Mr. Martin can decide to set it aside. If he still thinks it was a bargain at the price, cheap at the price, he can continue with it. It remains valid. So you get 3 different types of misrepresentation. Innocent misrepresentation is where I did not know. My car has been keeping up with its service record. It's not making strange sounds. I actually believe it is in a perfect working condition, but it isn't. So it's still a misrepresentation, but it was made innocently. Contract is voidable. It can be set aside, or he can uphold it. Negligent misrepresentation is if I believed something to be true, but I did not take proper steps to make sure that it is in fact true. So I tell him the car is in a perfect working order, but I haven't in fact had it serviced for the past 2 years. So I don't actually know whether it is or not. Then fraudulent misrepresentation. Fraudulent misrepresentation is exactly what you think it is. That is a blatant lie. I know I'm lying. I know I'm making a misrepresentation. In the case of negligent and fraudulent misrepresentation, the innocent party can either set aside or uphold the contract. Plus, in addition, they will have a claim for damages. So if the car died on the way to Okahanya and you had to pay a tow-in service to bring it to Windhoek, those will be damages, which you can then also make me pay, which you can claim from me. The last two factors that influence misrepresentation are duress and undue influence. Most law textbooks will discuss them separately. I've lumped them together here for your purpose because they are sort of similar. Duress, an unlawful threat of harm or injury made by one contracting party or someone acting for that party, which causes the contracting party to conclude the contract. So that is where I am telling Fabiola that if you don't buy my car, I will shoot your little sister. And she believes that I really will and that I am capable of doing it. That is duress. Once again, think with your heads and not with your hearts. I've told Fabiola, buy my car for $300,000 or I will shoot your little sister. She agrees to buy my car for $300,000. There is consensus. The contract is valid. Your gut reaction might be, but I threatened her. How can it be valid? Think with your heads, not with your hearts. Contract is valid. She has agreed. Sorry. She has agreed. My apologies for that. So there is consensus, but because consensus was obtained under duress due to my threatening her, the contract will be voidable and she can set it aside or uphold it. Undue influence is similar, but that is more to do with a person in a position of authority. Undue influence, unfair, improper, unfair conduct by one contracting party that persuades the other party to conclude the contract against the latter's free will. So that is where I am telling Fabiola, buy my car for $300,000 or I will make sure that you never pass sports law. She agrees. There is consensus. I obtained it due to using undue influence. Contract is valid, but there's something wrong which makes it voidable. It can be upheld or set aside. So that is consensus then. potential test question. I'm not going to answer that for you. Go and think about it. You're welcome to share the answers with me by way of a private message or on the group. Um, but that question is definitely going to be in your first test. Okay. Enough for today. We've covered everything we had to do. Any further questions? Okay, lovely. Thank you so much for joining. I will see you then next week, same time, same place. Bye.